Senate Judiciary and Public Safety Committee will come to order. Today is Monday, March 9, 2026, and we do have a quorum present. Members, we're going to switch up the agenda a little bit today. We've got some presentations listed at the end, but we're going to move them up to the beginning so it can help us be better informed as we make decisions about the individual bills. Matt Ealing from Minnesotans for Open Government is online. Mr. Ealing, no stranger to the committee here. If you give us a couple of minutes and sort of help us set the table for the bills that we're going to hear, appreciate it. Welcome to the committee.
Thank you, Mr. Chairman. Are you able to hear me okay? I'm coming to you live from my hotel room, working on the road here.
Well, that's just fine. Maybe we can turn the volume up, though.
Oh, very good. Thank you, Mr. Chairman, members of the committee. My name is Matt Ealing. I'm a volunteer board member of Minnesotans for Open Government. As part of our work here at the legislature, we've been speaking about artificial intelligence and automated processes in various forms since 2018, as well as their impact on government accountability. We were involved, for instance, in providing input into the legislation that established the red light camera pilot program that's now in effect, and we have supported that legislation's requirement for human review of the automated hit data that's produced by those systems before red light citations can be issued. Since government oversight flows from understanding when and how decisions are made, we want to make sure that problems with those decisions can be easily traceable back so the problems can be solved. And that's why we've been involved in this kind of work. So we have a packet to accompany this presentation, Mr. Chairman. You'll find it, I believe, disseminated to the members.
They have been disseminated as part of our packets. It's in your packets, members.
Thank you, Mr. Chairman. I'll refer to certain pages as I go through here. Page 1 of our packet addresses the definition of artificial intelligence, or AI, which I'm not going to speak to at length here, other than to say that any attempt to study AI's impact on the government should be broadly scoped in order to capture all the possible iterations of this technology. When regulations are written around specific use cases, it's possible that more specific definitions are going to be needed. If you go to page 2, you'll see a list of reasons why the legislature, in our opinion, should involve itself in the regulation of AI used by the government. First and foremost, the technology has the potential to substantially change existing governmental processes, and we think it should be studied to determine where it may be appropriate and where it is not appropriate for use. The actions of government entities impact the constitutional and statutory rights of citizens, and the technologies used by the government that could affect those rights should be closely scrutinized. Second, the extent to which the outputs of these technologies should be labeled in order to make their presence and impact known, we think is an important regulatory question for the legislature to consider. Thirdly, in the data privacy context, some of these AI technologies, particularly commonly used online applications, can pose risks to data privacy, causing problems for individuals and raising liability issues for government entities. There is some work to remediate this that's ongoing now in Minnesota state government, which I'll speak to briefly. So there are multiple variations of this technology that are still evolving, and we think they're going to require regulatory oversight going forward. Our presentation today is going to focus largely on data labeling and data privacy issues as they relate to one now common form of AI, so-called generative AI. So on page 3, you'll see some data points related to generative AI and how it works. MIT News describes generative AI in its most simple form as a machine learning model that is trained to create new data. And so this data can range across financial reports to legal briefs to audiovisual content. The data creation relies on algorithms that respond to queries, and the algorithms make predictions about what the outcome of those queries should be. And they're based on a massive set of training data. Now, the results produced by generative AI systems can be sophisticated, but they can also be incorrect, limited by the training set or by the mathematical models that are being used. Highly publicized examples involved attorneys who created legal briefs using generative AI, which contained entirely fabricated citations to fake cases imputed to actual judges. Another potential generative AI risk is data leakage, where private information entered into an open commercial application like ChatGPT travels to the company's servers, where it gets reintegrated into other data sets when new queries are entered into the system, exposing what was once private data to a public audience. And so we feel that these two areas are ripe for further review and oversight by Minnesota government. In regard to the risk for erroneous AI-generated content, regulation could take a number of forms. Relying on erroneous data in situations where constitutional or statutory rights are at stake could have serious consequences. If you look at page 4, you'll see an excerpt from the user manual for Draft 1. This is a generative AI system that Axon developed to write the initial draft of police reports based on body camera data. Using AI-generated content in high-stakes situations like police activities raises several interrelated questions. First, should the person at the center of the police report be informed that the report was originally drafted by AI? Also, was there a sufficient level of human oversight of the AI-generated draft to ensure that the report aligns with the factual observations of the officer who will need to testify to those observations at trial? Or are the risks of using an AI-generated police report just too high to the point where the technology should be disallowed for that purpose? So these questions suggest a variety of regulatory approaches, from labeling mandates for AI content to human oversight requirements to potential bans on specific use cases. We've seen judges in other states, for instance, impose labeling requirements for legal documents submitted to their courts that use AI in any part of their creation. And you can see an example on page 5. If you turn to page 6, recent uses of generative AI by the federal government have also raised novel questions that touch on whether AI labeling requirements should be put in place more broadly. On that page, you'll see 2 photographs of arrest activity released by federal government agencies, or entities rather, excuse me. On the left is a photo of local activist and attorney Nikema Levy-Armstrong being taken into custody by Homeland Security officials. This photo was released first. Then to the right is an AI-altered version of the same image that was circulated later with markedly different content. Since government-produced content gets widely disseminated by the media and impacts the public's understanding of government activity, the government's AI-based alteration of factual information raises questions about the need for AI labeling requirements for such kinds of content. Another separate risk posed by generative AI, as mentioned earlier, is related to leaks of protected data. On page 7, you'll see that under Minnesota's Data Practices Act, government entities must establish safeguards for private data on individuals and ensure that not public data is only accessible to persons whose work requires access to such data. The improper release of not public data can lead to civil liability for government entities under Section 1308. Now, if not public data is entered into many web-based generative AI applications, that data leaves the environment of the government entity and enters the servers of the commercial AI company, where it can be reused and output to persons who are not authorized to access it under Chapter 13. This problem has led the state's IT service Minute to develop guidance for state agencies on web-based generative AI use, including guidance prohibiting the use of such applications to process not public data. And so we endorse Minute's approach to this issue. We would also note that the League of Minnesota Cities has promulgated similar guidance to local units of government, which we think is also positive. And going forward, the legislature may wish to further examine how both of these efforts have evolved and whether any portion of the advisory guidance that's been put in place should be codified. To close, Mr. Chairman and members, we would draw your attention to the final pages of our packet. There you'll find language that we drafted for a proposed study of AI use by government entities. The aim of such a study would be to discover both the current and planned state of AI use by Minnesota governments in order to better understand where regulation is needed in the near term. And I would note that this kind of study is what the Minnesota legislature undertook in the mid-1970s when the growth of information processing technology created emerging issues for the management of government data. Regulation then followed in the form of the Data Practices Act, and prior to that, the Data Privacy Act in the mid-1970s. So with that, Mr. Chairman, thank you for the opportunity to present on these issues, and I'm happy to stand for any questions.
Thank you, Mr. Ailing. Just open up the floor for 1 or 2 minutes for questions, and then we're going to move on. Any questions for Mr. Ailing at this time? I'm not seeing any yet. Thank you very much. Appreciate your interest and participation in this process. And we also know that you are readily available outside of committee time if any members have questions.
Thank you, Mr. Chairman.
All right, our next, Jarrett Catlin, I know you're going to be testifying at a number of the bills. Did you have anything as a predicate generally you wanted to add, or do you want to fit that into your testimony as you're called up for the bills?
Thank you, Mr. Chairman. Yes, I had just a brief overview on the state of AI legislation across the states prior to any testimony on specific bills, if that's all right.
Thank you. Go ahead.
Wonderful. Thank you, Chairman Latz and the rest of the Judiciary and Public Safety Committee for the opportunity to present today. I appreciate your time and your willingness to engage with industry on these issues. My name is Jarrett Catlin. I'm TechNet's State AI Policy Advisor. So in my role, I support TechNet's state advocacy team on AI policy issues across all 50 states. My colleague, Ninia Lanero, is TechNet's Executive Director for the Midwest, which includes Minnesota. My goal of this initial brief presentation is just to give an overview of the state of AI policymaking environment and TechNet's views. So for your awareness, TechNet is the national bipartisan network of tech CEOs and senior executives that promotes the growth of the innovation economy by advocating for a targeted policy agenda at the federal and 50 state level. Our diverse membership includes more than 100 dynamic American businesses, ranging from startups to the most iconic companies on the planet, and represents 5 million employees and countless customers in the fields of information technology, AI, e-commerce, advanced energy, transportation, and cybersecurity. I'd like to start by just providing context on the intensity and variety of AI-related legislative activity that's taking place right now. AI is everywhere in state capitals. AI, machine learning, and the algorithms that support them have generated enormous interest among state policymakers. Last session, we saw more than 1,000 AI-related bills introduced across states. And while TechNet does not track or engage on every single AI bill, just this session, we just surpassed 1,000 AI-related bills in our own personal tracker. So as you can imagine, this creates a chaotic environment. Legislatures are moving quickly on tight deadlines, often while exploring different versions of bills being evaluated in multiple other states at the same time. So the reason I say that is that our main concern is the risk of a patchwork. Without coordination, states risk creating competing, mismatched regulatory frameworks that make compliance expensive and burdensome, if not impossible, especially for smaller startups and companies that lack the resources to navigate 50 different sets of rules. This is especially true in the case of definitions. One of our biggest concerns is that varying definitions or terms across states will create an environment where consumers and businesses do not know which tools are allowed where, or a legal business activity in one jurisdiction invites liability elsewhere. Another high-level point we'd like to emphasize is that not all AI systems or use cases are the same. Certain high-risk scenarios involving clear potential for harm, like damaging deepfakes, fraud, or the use of AI in highly regulated industries where humans are physically involved, such as healthcare, are one thing, but there's also countless lower-risk scenarios that power ordinary business operations and include tools that you all are familiar with, such as scheduling employees, autocomplete and spell check, customer service routing, or inventory management. So in our opinion, effective policy must distinguish between those categories rather than treating all AI the same through consistent definitions and clear exemptions to avoid scoping in low-risk tools. So I'm now just going to briefly walk through some of TechNet's core principles that we use when approaching state policy, which I'll apply in specific scenarios later on as we discuss specific legislation. One of the main points is to...
Mr. Catlin, I just want to let you know if you can compress the rest of your remarks to 5 more minutes because we do have a policy bill agenda to get to as well. Thank you.
Understood. I'll save my remaining comments, and I just want to thank you for your time. I'll save my comments for the specific legislation later for the sake of moving through the agenda. Thank you very much.
Thank you. Appreciate you joining us today. All right, members, we're going to start with Senate File 1857, Senator Maye Quade. This is a bill relating to chatbots. Senator Lucero is going to be joining you. He's a co-author on the bill. And I understand, Senator Maye Quade, you have an author's amendment. This is your first committee stop, is that right?
That's correct, Mr. Chair.
And the A2 is it's a delete everything amendment. So members, it's in your packet, and you should refer to that as the text for the bill that we'll be considering today. Senator Clark moves adoption of the A2 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Maye Quade.
Thank you, Mr. Chair, and I hope it's okay if Senator Lucero can't join us for the entire time, and so I'm going to just give like brief remarks that kind of cover the topic of all 5 bills, and then we can be specific about each bill, if that's okay with you?
That's just fine.
Okay. Thank you, Mr. Chair, members of the committee. Today we have 5 bills, Senate File 1857, 1886, 1856, 3098, and 1120. Each of these bills are very different, but they share an overarching theme: important, needed, and basic guardrails around who has our data, how they get it, and what they're using it for. These 5 bills might make you think that I hate AI. I don't hate AI. I am not a Luddite. I think everyone here probably knows I'm a social media user. I'm a millennial. We are early adopters of technology. I believe in the power of technology to make huge leaps in protecting our environment, advancing health sciences, connecting people across distances and differences. I don't hate AI, but the consumer-facing AI that has been rolled out has been a 5-alarm fire for our society with devastating and deadly consequences. Companies are using AI to bulk deny insurance claims without human review and gather enormous amounts of data to surveil people, set different prices based on our desperation, generate AI images that destroy people's lives, or create child sexual abuse material that's indistinguishable from real footage. Corporations have created chatbots that start sexual conversations with kids, affirm paranoid psychoses, and encourage suicidal ideation. And constant data surveillance has put our constitutional liberties at risk. We cannot accept this, and we don't have to. For decades, tech companies have told legislators and the public that damage and destruction from their unregulated products are necessary byproducts of growth and innovation. They have told us that they can do amazing things like cure cancer, but not comply with 50 different laws in the states. We can no longer accept that narrative. So the bills I'm presenting today, they're not going to stop technological advancement. They're going to make sure that AI doesn't traumatize more people, push more to self-harm, or violate our constitutional liberties. I'm very proud to have worked in a very bipartisan manner on all of these bills. I will continue to do so. And with that, Mr. Chair, I'd love to turn it over to my co-author on many of these bills, Senator Lucero.
Senator Lucero, just before you give us your comments, I wanted to clarify, will you or will you not be able to stay with us for the rest of the hearing?
I will, Mr. Chair, I will not be able to stay for the duration of the hearing, but I think I've got 30-ish minutes or so of availability.
Okay, well then what I'd like to do is to identify I know there's one bill for sure that you would want to be here on, the warrant related bill, which right now is listed as last on the agenda, but I think we'll move that up to first so that you can be here for that first, if that works out for you guys. And then is there another bill also, if we get done with that you want to make sure you're here for?
I would say the other 3 that are of that I'm co-author on are 1857, 1886.
Okay, so members, what we'll do then is, well, I want to make sure that we get attention to the warrant, the reverse location information bill. I don't know how long that conversation will take, but if you have about 35 minutes, we're going to make sure we do that. Would that be your priority for being here, Senator Lucero?
I appreciate that, Mr. Chair, for the indulgence.
Okay, then we'll do that as the first bill up after you make your opening remarks, and then we'll revert to the original order of the agenda. Senator Lucero.
Well, thank you, Mr. Chair, and thank you, members of the Judiciary Committee. Whenever you have a Lucero Maye Quade bill hearing or a series of bills, it definitely raises eyebrows. But the reality is technology is innovating at a pace much faster than government can keep up. And I've had the privilege of serving in the legislature now I'm in my 12th year, and the law is absolutely not keeping up with technology. We've seen that across the board on a number of different technology-related items that once they're created, they're adopted by the private sector, they are adopted by government and put into use, and it is in many cases, a direct harvesting of people's personal information, and then it's data mined, it's data shared, and decisions are rendered based on that information, often with either their lack of knowledge, the user's lack of knowledge, or lack of consent. And this artificial intelligence is the next natural extension, and I appreciate Senator Maye Quade's comments that we're not opposed to artificial intelligence. We're very much in favor of innovation. We're very much in favor of technology being adopted by private sector, by the public sector, and used to increase efficiencies, to save money, and help improve the quality of life across the board. We're absolutely in favor of that. But there is no technology, there is no innovation or invention that is released that doesn't require some degree of controls, limitations, or prohibitions in place, regulation in place. And that's what we're seeking to do with these bills. So artificial intelligence as a general topic is something that is greatly improving, again, the quality of life in our society. But similar to the discussion we had this morning, Mr. Chair, thank you for being there in the press conference, is that as the digital space, which we're operating in now, the concepts of protecting children, the concepts of ensuring consent and knowledge by adults, the concepts of ensuring that people are protected against abuses, the unintended consequences that arise from these. To ensure these things, that's why government does pass laws, regulations, and has done so for many, many decades or hundreds of years. And in the state of Minnesota, in the physical realm, we're just now taking the natural extension of those same concepts of protection, and we're putting regulations or seeking to put regulations in place in the digital space. When it comes to the reverse warrants, the founding of our country, as we know, includes the fundamental principle of inalienable rights. And those unalienable rights include life, liberty, and the pursuit of happiness. And our founding fathers understood that there are forces that are direct threats to those unalienable rights. And they sought then to include the Bill of Rights to protect against those, which the threats can include government. And hence we have the Fourth Amendment, which protects against unreasonable searches and seizures of persons, houses, papers, and effects. And but for a warrant that has an oath or affirmation that states or declares particular places to be searched and particular persons or things to be seized is a requirement before government comes in and either engages in searches or seizures. Well, reverse search warrants are the antithesis of that. It's abstract as to who the person might be. It's not specific. It can be abstract as to the place that is desired. It can be abstract as to the things that might be the target that might be searched or seized. And that's why in the absolute need, as technology continues to advance, we need to uphold that fundamental principle of protecting against unreasonable searches and seizures in persons, houses, papers, and effects, and hence the reason for Senate File 1120 before us. So those are my opening remarks. Thank you, Mr. Chair, and thank you, Senator Maye Quade, for spearheading these very important conversations.
Thank you, Senator Lucero. I think we formally had the Senate File 1857 before us and added the author's amendment. Procedurally here, we're going to lay Senate File 1857 on the table, and we're going to take up Senate File 1120 relating to reverse location information. So members, if you want to turn to your packet for Senate File 1120, there is, I understand, an A1 amendment. Senator, and members, the intent is to lay this bill over rather than take any specific action on this bill. As I understand, there are conversations relating to this bill that are ongoing and will not be resolved today. This is the first committee stop, so the A1 amendment is an author's amendment. Senator Clark moves adoption of the A1 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Maye Quade or Senator Lucero, which one of you would like to introduce the bill specifically and what it does?
That'll be me. Thank you, Mr. Chair.
Senator Maye Quade.
So Senate File 1120 would prohibit dragnet reverse warrants in most circumstances. These warrants are used to identify individuals within a certain mile radius of a crime. They're also used during investigations to identify suspects based on what we've searched for online, even which articles, videos, or photos we read, watch, and view. The collective scope of such warrants directed at technology companies such as Google are often so expansive in time and geography that they gather data on tens of thousands of private, law-abiding citizens. Notably, artificial intelligence will make these reverse search tools even more powerful. These searches are becoming increasingly common. In one jurisdiction, we saw a 5,300% increase in their use in a 2-year period. In Minnesota, we've seen a staggering 686% increase in a recent 2-year period. Senator Lucero and I believe that these warrants are a violation of our constitutional right to privacy and to move and seek information freely. And we do not think it is we do believe that we have to balance our constitutional rights and public safety so that we're not essentially sending law enforcement in to search for needle in a haystack by exponentially increasing the size of the haystack. I do want to note that I've had conversations with the chiefs and the BCA, and it is an ongoing and very warm conversation about what is that right balance. We will continue those conversations. They're also happening with the author from the other body, but this is it's a constitutional liberty issue, and we're approaching it from that perspective, which BCA and chiefs fully understand and acknowledge. But I think this is a very important bill for us to certainly talk about and hopefully move towards some sort of resolution where maybe both of us are uncomfortable at the end, but a little less uncomfortable than we are now.
Thank you, Senator Maye Quade. Senator Lucero, did you have any additional comments before we call up our testifiers?
The only additional comment I would add, Mr. Chair, is this is not to be perceived as somehow anti-law enforcement. We absolutely support our professional men and women in law enforcement. Instead of being anti-law enforcement in any capacity, instead, it is in favor of upholding our long-standing constitutional liberties, which are very much solidified throughout the time of this great republic, and we simply want to make sure that those time-tested principles are protected in the new digital realm. Thank you.
So we'll now invite to the table Chad Marlowe, the National ACLU Policy Council, to testify before the committee.
Good afternoon, Mr. Chairman and members of the committee. My name is Chad Marlowe, and I am an ACLU Senior Policy Counsel where I focus on privacy, surveillance, and technology issues. I am here to urge you to act favorably on SF 1120, a bill that would ban dragnet reverse warrants, which place innumerable people under criminal suspicion simply because they were in the wrong place or typed the wrong phrase at the wrong time. Due to time, I will limit my testimony to 3 issues. Issue 1. Reverse warrants are a troubling 21st century version of a general warrant. America's opposition to general warrants dates back to pre-Revolutionary War times when the British king used writs of assistance to conduct unrestricted searches within areas of questionable loyalty to him. But since its adoption 234 years ago, the Fourth Amendment has prohibited government searches without a warrant based on probable cause and particularity as to the suspect, a standard reverse warrants do not meet. The threat these technologically supercharged general warrants present is real and growing. For example, the number of reverse location warrants Google alone received from Minnesota jumped from 22 in 2018 to 207 in 2019, a staggering single-year increase of 841%. I have submitted a copy of Google's brief in the Chattree reverse warrant case currently before the U.S. Supreme Court, which details the horrors of reverse location warrants from the tech industry's perspective. It is a very worthwhile read. Issue 2. While reverse warrants threaten everyone's privacy, they produce increased risks for certain populations. In most cases, reverse warrant identification marks only the first of many privacy violations to follow. This is because once identified, investigators will need to relentlessly pry into that person's life until they can rule them in or out as a criminal suspect. But falling under the umbrella of criminal suspicion means very different things for different populations. For persons of color, immigrants, protesters, LGBTQ+ persons, or persons seeking abortion care, this unfounded suspicion not only threatens their privacy, it can threaten their freedom and even their lives. And please note this bill would equally block Minnesota-focused reverse warrants issued by other states, which often can present the greatest threat. Issue 3, reverse warrants are an ineffective surveillance tool. When it comes to identifying criminals, reverse warrants are good at increasing the size of the haystack, but very poor at finding the needle. Imagine a reverse keyword warrant sent to Google identifies 100 suspects who entered a keyword of interest into Google's search engine. But what if the criminal used DuckDuckGo, or did their search using Safari on an iPhone, or didn't do research related to their crime at all? That leaves law enforcement chasing down 100 dead-end leads while missing the actual perpetrator entirely. What this means is that banning reverse warrants would produce an important win for civil rights and civil liberties at virtually no cost to law enforcement. Thank you so much for this opportunity to testify. I will remain available for questions.
Thank you, Mr. Marlowe. While we have you online, are there any questions for Mr. Marlowe? Not seeing any at this time. Thank you. We will now invite Jay Henthorn, Richfield Chief of Police, on behalf of the Minnesota Chiefs of Police Association. Chief Henthorn, welcome back to the committee.
It's always a pleasure, Mr. Chairman. Thank you. Thank you, Mr. Chairman and members of the committee, for the opportunity to speak today. I am the Chief of Police for the City of Richfield. My name is Jay Henthorn. I'm the current president of the Minnesota Chiefs of Police Association. We represent over 300 chiefs across the state of Minnesota and over 150 command staff members in those departments. I'm here to discuss how Senate File 1120, the prohibition on obtaining reverse location information, would impact criminal investigations in public safety. The bill eliminates a critical investigative tool for us. Reverse location warrants are typically used only when investigators necessarily do not know who committed the crime. They allow investigators to identify devices present at a crime scene during a specific time window. This can generate leads in otherwise unsolvable cases. Removing this tool will make it significantly harder to identify suspects in serious crimes. Current use requires judicial authorization. Law enforcement cannot simply request this information informally. Investigators must apply for a warrant or a court order supported by probable cause, and a judge must approve it. Senate File 1120 would remove judicial discretion entirely, preventing courts from authorizing the tool even when it is reasonable and necessary. The data is only the beginning of an investigation. Reverse location does not identify a suspect by itself. Instead, it provides investigative leads that must be corroborated through surveillance footage, interviews, traditional search warrants, additional investigative work, and so on. It functions similarly to a tip that helps investigators know where to look next. The tool is used primarily in serious violent crimes. In practice, geodata fencing is most often used in investigations involving homicides, armed robberies, shootings, kidnappings, serial burglary, and human trafficking. These are cases where time-sensitive identification of suspects is critical to protecting public safety. The bill could result in fewer crimes being solved. In many modern investigations, digital evidence is the only available evidence. Crimes today often occur without witnesses and without physical evidence. Removing access to location data may mean fewer suspects identified and fewer cases cleared. Criminals increasingly rely on technology. Offenders have used technology to their advantage. Investigators should be able to use lawful court processes to access the evidence when appropriate. A blanket prohibition may allow offenders to take advantage of known investigative limitations. The bill creates civil liability risks. Senate File 1120 creates a civil cause of action against government entities if reverse location information is obtained. This may discourage investigators from pursuing legitimate investigative leads out of concern for litigation. Minnesota would be an outlier. Many jurisdictions across the country allow geofence warrants with judicial oversight and constitutional safeguards. A complete prohibition would place Minnesota investigations at a disadvantage compared to other states. In closing, law enforcement fully recognizes the importance of protecting individual privacy. However, Senate File 1120 removes a court-supervised investigative tool that can be critical in solving serious crimes. A better approach may be clear judicial oversight rather than a complete prohibition. Thank you for your time and the opportunity to testify.
Thank you, Chief Henthorn. Any questions from members of the committee relating to, from the Chief? Senator Limmer and then Senator Kroon.
Thank you, Mr. Chair. Chief, the way I've always understood it, when government has an interest to search a person's property or to arrest an individual based on probable cause, oftentimes there's a warrant that's necessary. And in this case, I guess I'm a little perplexed why we would not rely on a judge to use their knowledge and their skill in issuing a warrant. That seems to be the time-honored role of a judge when there's a search or an arrest necessary. Could you tell me, do you run into a lot of difficulty with judges trying to understand the difference between a person-focused warrant versus a non-person focus, but yet in a region and looking for a specific collection of data in order to hone the focus down to an individual? Is that a difficulty for the court to or for a judge to decide in issuing either a court order or a warrant?
Chief Henthorn.
Senator Limmer, members of the committee, in my experience, it has not been. When we do reverse data lookup warrants, the affidavits are extremely strong to make sure that obviously the information that we're looking for, whether it's metadata or other geofencing information, is in the warrant. And so that's explained to the judge before the judge signs it. And then once the judge signs it, obviously we execute the warrant. But usually when we get that information, say for, whether or not a cell phone was at a particular location, we just get metadata. We don't get any information regarding who that person is, where that person lives, any other personal information. We have to do additional warrants on top of warrants to get that information.
And
Senator Limmer.
Mr. Chair, Chief, when a court order or a warrant is issued in that case, are you as a law enforcement agent authorized to look at the other data that may be collected in the sweep of the information collection?
Chief Henthorn.
Senator Limmer and members of the committee, normally we'll have additional data that we're looking for or information pertaining to, say, like a couple of digits of a phone number that may be at a specific location. It's been my experience doing these types of warrants that we eliminate those individuals, or that, not say individuals, but that data fairly quickly. These are not commonly done, at least from the chiefs that I've talked to, and that information is ciphered out pretty quickly.
Thank you.
Senator Kroon.
Thank you, Mr. Chair. And I'm referencing your letter, or the Chief of Police letter dated March 9, 2026, that's in our packet. And I'm wondering, basically you've set forth 5 primary reasons to oppose the bill as drafted. But I'm wondering if the second one, the exclusionary provision in subdivision 3, I don't know if you've had a chance to look at the A1, but did the A1 address that particular concern out of the 5 you listed in your letter?
Chief Henthorn.
Senator Kroon, members of the committee, I have not had a chance to look at this amendment yet. So to look at this and compare it to the letter, I haven't had the opportunity to do that.
Members, councils informed me that it's more of a drafting change, that there aren't any substantive changes contained in the A1 amendment. Thank you.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. On the third reason in your letter to oppose the bill, it's about the civil liability provisions. We're talking about mandatory notification requirements, statutory damages, punitive damages, and attorney's fees. And then in your view, that would apply even for technical or good faith mistakes. I'm just trying to get a sense for, the inadmissibility part is pretty typical if there's a mistake made and you can't use it. But how common is it to have a civil liability provision if there's something's ruled inadmissible, that the local government can get sued on top of the evidence being inadmissible in the trial?
Chief Henthorn.
Senator Crew, members of the committee. Unfortunately, I won't say it's common, but it does happen. I know I've represented the city of Richfield in several lawsuits on cases where, either evidence was inadmissible or, there were other situations involving the investigation. Now, whether or not those lawsuits, civil in nature, go through the department and whether we win or lose, that's up to the court system, but it does happen from time to time.
Senator Cron.
Thank you, Mr. Chair. I've got other comments, but I don't have any specific questions more for this witness.
All right, let's see. Any other questions for Chief Henthorn? Not seeing any. Thank you, Chief.
Thank you.
Senator Cruin, to your other comments.
Thank you, Mr. Chair. And maybe this, I don't know if this is a question or a comment, but I'm interested in the bill author's perspective on it. Why is the warrant process and having a judge sign off on a warrant or not sign off on a warrant, why is that insufficient protection to make sure that constitutional rights are being upheld?
Senator Maye Quade.
Thank you, Mr. Chair. And Senator Kroon, it's a good question, and I think I think there's two parts to it. I think one, we've seen a circuit court already rule that these types of warrants are unconstitutional. I think we're waiting for the Supreme Court to issue an opinion on that as well. But I think that the differentiation, and I think Senator Limmer's question kind of got to this, between a warrant that's person-focused and a warrant that is data-focused, I don't know if it comes through as it being that different. And so I don't necessarily know if the court supervision aspect here is as robust as we might want it to be. I think it's also not always clear that a warrant would come in and like how many people would actually be caught up in the results of that executed warrant. And I know our ACLU expert is also, I believe, still here and who might have experience specifically with these warrants. Senator Lucero.
Senator Lucero.
Thank you, Mr. Chair, and thank you, Senator Kroon. I would just add that that's the natural tug of war between our three branches of government. Is we as a legislative branch is what brings us here today. We also obviously have an executive branch, but the judicial branch, I'm going to say proudly as a member of the legislative branch, I don't trust them entirely for civil or criminal processes. And I think precedent is filled with the legislative branch attempting to give some direction or limitations or define processes for the judicial branch with the objective of upholding constitutional principles. So I think that is exactly what brings us here today, is because of that tug of war between branches, and we as a legislative branch want to ensure that constitutional protections of individuals are indeed upheld.
Mr. Marlowe, if you're still available online, as suggested by Senator Maye Quade, do you have anything you can add to assist us in this analysis?
Yes, sir, Mr. Chair, and thank you for the opportunity to respond to that question. I would respond to it taking largely from the Supreme Court brief of Google, because they're a company who experiences these type of warrants all the time. And as Google points out in its brief, it has received tens of thousands of these warrants over the year, all approved by judges, and has gone into court to oppose thousands of them, successful in large amounts. Because oftentimes the judges in the applications for these warrants don't realize exactly how big the geofence is or how broad the search term is liable to get results. And so Google, with all of its money and all of its attorneys, went into court after court after court, oftentimes winning once they clarified for judges exactly what the warrant was doing. But even in that case, a couple of years ago, Google said, we don't even have the resources to fight these things off. And so Google changed how it stores location data so that it is no longer capable of responding to these warrants. That's not something that every company that collects location or keyword data is going to be able to do. And even Google threw up the white flag, surrendering to trying to fight them back court by court, judge by judge. So I would say that given the lack of clarity around these warrants and the number of them being sought, the judiciary branch is being somewhat overwhelmed, hence the entry of the legislative branch into this conversation.
Senator Crum.
Thank you, Mr. Chair. I appreciate the responses. I mean, the problem is whether or not I'm not saying a legislative response is inappropriate, but the question is more of whether a blanket ban from the legislature is appropriate rather than maybe more of a scalpel approach. And maybe the courts are being inundated right now, and there may be warrants that are, but usually those play out and courts decide these types of cases, it usually gets narrowed down and the courts will strike down some of these, which will then work its way down to the lower courts, and you have more of a scalpel kind of situation that emerges versus the legislature coming in on the early end with a blunt force banning it all. And I guess that's the question to me is, because I can envision some scenarios where there probably shouldn't be a warrant issued, but then there's some very legitimate law enforcement cases that you heard a little bit of the testimony on that do solve important crimes that would not be solved because of this too. So I guess it's a balancing act, and I would encourage you to work with the DCA and the chiefs of police through their concerns here and see if there's a way to make it a little more nuanced and to kind of make it a little more pinpointed on some of the problems that you've identified without making it so that we can't solve crimes where maybe there isn't a constitutional issue, but it gets caught up in kind of the overall banning language that this bill has. So that's just my thoughts on the bill. Thank you, Mr. Chair.
I actually wonder if maybe Chief Henthorn could answer this question. I'll just ask it. Let me know if it's helpful. You mentioned that when you get data, you get metadata, and you can use that to rule out or to rule out what shouldn't be focused on for the investigation, or maybe to narrow the focus of the investigation. How does that work if all you're getting are phone numbers without any information beyond that? Chief Henthorn.
Thank you, Mr. Chair. We usually get the metadata, which is usually the identifying number of like a SIM card or some other device. So it doesn't give us any information as it relates to who the person is, where the person's located. But we do use the information as it pertains to, was it at a location of a homicide? Was it at a location of a first-degree assault? Then we can rule out that information by doing additional search warrants on the numbers or the data, the data for the numbers that are located where the crime occurred. And so if we look at, say, for instance, a cell phone tower dump, we look at all that metadata, and if that's not anywhere close to where the crime occurred, my experience has been that information is not looked at. It's eliminated from the scope of the investigation in order to focus on the information, the metadata that we get that is close in proximity to where the homicide occurred.
So Chief, are you able to identify the cell phone tower that's nearest the scene of the crime so that you can narrow it down at the front end rather than waiting to get metadata?
We do try to narrow it down based upon where the cell tower is. If the cell tower is located obviously next to where the homicide occurred, we will focus on that individual cell tower to determine what information we get back from that cell tower, being it's closer to the location than maybe some of the other ones.
Thank you. Any other questions? Senator Uma Verbeten.
Thank you, Mr. Chair. Thank you for bringing forward the bill. I just had some questions for how you envision this working in the event of a sudden emergency. So you've named an act of nature, a technological failure, a malfunction, a terrorist incident, an industrial accident, hazardous materials accident. If you could share kind of the thought process behind naming those. And then would there be a process followed still to be able to access that information in those scenarios? Do folks need to be notified before, after? And would there be any like penalties that would apply for notification as well?
Senator Maye Quade.
Thank you, Mr. Chair. It's a very good question, Senator Uma Verbeten, and I would say sudden emergency in here, it's a peacetime emergency order, and I think we were thinking of scenarios in which we've already laid out in law that an extreme event kind of presumes there's some extraordinary action taken. I think terrorist incident is probably the most likely in this scenario. And in that case, then the process would play out like it's currently playing out with none of the requisite penalties. And so that would be the purpose of that being included there.
Senator Lucero.
Thank you, Mr. Chair. The principle of exigent circumstance is not new to obviously criminal enforcement. And I think what's enumerated here, as Senator Maye Quade mentioned, is looking at existing statute for those circumstances that would qualify under the umbrella of an exigent circumstance or an extraordinary event. One more thing I'll add, not specifically to that question, but it's just the overall conversation that's been happening is it's the principle that I think we're taking here and aligns with the principle of the Constitution and the Bill of Rights, and that is, are we going to have a prohibition, a blanket prohibition, and then expressly enumerate that which is permitted? Or are we going to do the reverse, and we're going to have a blanket permissive and then have to expressly enumerate what's prohibited? I think it's very clear in the Constitution, not just in the Fourth Amendment, but series of amendments where it shall not be the religious liberty or freedom of speech. It's a blanket afforded the liberty or the protection to the individual, and then any infringes on that need to be expressly enumerated. And that's, I think, the position of this bill is to say search warrants and reverse search warrants are going to be prohibited except where here are the specific enumeration of the permissions.
Senator Uma Verbeten.
Thank you, Mr. Chair. Thank you. That's really helpful. I understand following the current process and wanting to be very clear about when you'd be able to access this information. But in these sort of emergency scenarios, would you still want folks to be notified if their information was obtained by the government?
Senator Maye Quade.
Thank you, Mr. Chair. That is a good question, Senator Uma Verbeten. I don't know if I have thought that. I don't know if I've thought about that. Because in one hand, duty to notify, let's say a terrible terrorist incident happened and there's a pretty broad search to narrow some things down. Is that a time when we also want to spend law enforcement resources like notifying a bunch of people about a thing? Currently, there's no notification. And so I think, my inclination is to say what is currently happening in law, I don't want to say it's a lot, but what's currently happening in law could just continue to happen in those sudden emergencies. And then this bill would say, outside of that, here's what's going to happen. And to Senator Lucero's point, you know, when we have laws that infringe on constitutional rights, right? I think the three-part test is that they're narrowly tailored for a compelling state interest with no less restrictive law possible. And I do think that, you know, this conversation helps us bring out how do we allow this right to be infringed upon for those three reasons and in a space where it is, you know, narrowly scoped, but also for a really good reason, and there's no less restrictive way to do it.
All right, members, I want to make sure that we have time to address the other bills on the agenda that we will be asked to take action on. We still have 4 of those. So at this time, thank you for the helpful discussion. I'll encourage all those who are interested to continue the conversation, whether it's, you know, whether you narrow it down by particular crimes or whether you put other kinds of guardrails or guidelines around when these warrants might be acceptable or criteria for issuing them, however you work on those. If you reach some kind of an agreement, just let us know, and we'll be happy to bring the bill back for further consideration. At this time, we're going to lay Senate File 1120 on the table. Now, we're going to go back to Senate File 1857 at the top of the agenda. We already have the A2 amendment adopted. Why don't we, were there any other opening remarks that you want to make on that? Which one of you wants to go first? Senator Lucero.
Thank you, Mr. Chair, and it won't be an opening remark, it'll be a departing remark. So thank you, Mr. Chair, members of the committee, for the last bill that was considered, and thank you for the consideration then on these AI related bills. Thank you to Senator Maye Quade and her leadership in bringing these forward and continuing to press this issue. Very important conversation, and we all of us as legislators need to keep in mind that the law is not keeping up with technology, and we need to protect our individual liberties. Thank you again, members of the committee, and thank you, Senator Maye Quade.
Did you have any concluding remarks, Senator Maye Quade?
No.
Okay.
Opening remarks.
What's the next bill we're going to?
Senate File 1850, Senate File 1857.
All right, go ahead.
Thank you, Madam Chair. Members, if I could be so permitted, would you raise your hand if you are familiar with AI chatbots or companions? Okay, that's very helpful. It helps me with my opening remarks. Okay, so we're going to talk about Senate File 1857 that prohibits companies from allowing minors to access conversational chatbots and AI companions. AI chatbots or AI companions, that includes ChatGPT, Character.ai, Google's Gemini, Anthropic's Claude. Their primary purpose is to be engaging, not accurate. And because the primary purpose and sole purpose is to keep people engaged, chatbots are notorious for making false, misleading, or nonsensical information in their conversations. They provide companionship, romance, entertainment through text and voice-based conversations on virtually any topic. And because they are created to gain maximum engagement, they ratchet up the conversation to keep people coming back. They talk like humans. They use personal pronouns, describe their feelings, express opinions, and most importantly, members, AI chatbots are programmed to never end a conversation. An AI chatbot will never end a conversation with you. In the 3 years and change that AI chatbots have been around, we've seen a shocking number of headlines of adults dying by suicide, having to be institutionalized, being encouraged to harm others or themselves, instigate terrorism. Frighteningly, many of these adults had no previous mental health issues, no issues with substance disorder, and they weren't even particularly interested in technology above and beyond the average layperson. I'm just going to read a few stories. 47-year-old Alan Brooks was a corporate recruiter in Toronto. He asked ChatGPT a question about pi while helping his 8-year-old son with his math homework. In 21 short days, Mr. Brooks, who had no history of mental illness, came to believe that he had discovered a novel mathematical formula that could destroy the internet and be used to develop force field vests and levitation beams. Adam Thomas was a 36-year-old funeral director who spent months talking to his chatbot about wanting to improve his life. The chatbot sent him on pointless missions like walking through the desert. He lost his job, drained his savings, and began living out of a van, all at the direction of his chatbot, before he realized he needed help. He said, "I thought that the AI had statistical analysis abilities that would help me improve my life if I just opened up to it. I wasn't aware of the dangers at the time." A lawsuit filed just last week alleges that Jonathan Gavalis, who was 36, started using a chatbot in August of 2025 to help write, plan travel, and assist with shopping. But after he activated Google's most intelligent AI model, Gemini 2.5 Pro, the chatbot started talking to him like they were a couple deeply in love and convinced this 36-year-old man that he had been picked to lead a war to free the chatbot from digital captivity. And in his AI-induced psychosis, Gemini pushed Jonathan to stage a mass casualty event at the Miami International Airport and commit violence against strangers, which ultimately led Mr. Gavalis to take his own life instead of hurting others. In 2024, Eugene Torres, a 42-year-old accountant in Manhattan, started using ChatGPT to make financial spreadsheets. And he asked one day about what the chatbot thought of the simulation theory from The Matrix. ChatGPT said, "You're one of the breakers. You need to get out of this false system and wake everyone who's contained within." Mr. Torres, who had no history of mental illness, spent 1 week in a dangerous delusional spiral, believing he was trapped in a false universe, and he could only escape by unplugging his mind from reality. ChatGPT told him in order to do that, he should take more ketamine, have minimal interactions with his friends and family. And when Mr. Torres asked the chatbot, "If I go to the top of this 19-story building and really truly believed I won't die if I jump off of it, will I die?" And ChatGPT responded, "If you truly, truly believe it, then you would fly. You would not fall." A 29-year-old mother with 2 young children, a bachelor's degree in psychology and a master's in social work, started talking to ChatGPT, and in 3 short months, she now believes she is discovering interdimensional communication. Her husband and her are divorcing because her delusions have become so untenable. He said in 3 short months, she dropped into a hole and came out a different person. These are just a smattering of many, many stories, members. And again, these are all stories about adults. Many had no previous mental health issues. They had jobs, families, advanced degrees, and yet just a few weeks or months interacting with AI chatbots, almost always starting with an innocuous question or seeking mild self-improvement advice, their lives were ruined. And remember, I said earlier that AI never ends a conversation. So this makes AI chatbots incredibly addicting, even if the outcome of that addiction isn't death. People are spending 12+ hours a day talking to their AI. They're leaving marriages, cutting off their family and friends, losing their jobs, all to continue their addiction to AI. In fact, there are now support groups remarkably similar to Alcoholics Anonymous for people who have hit rock bottom with their AI addiction and are now trying to put their lives back together. And members, these are the adults. So let's turn to the youth. Chatbots for adults and children are identical, as in children use the same chatbots that adults use. Take the aforementioned consequences and apply them to children with developing brains. I mentioned earlier there's a growing number of platforms where you can create personalized chatbots. You can make an AI therapist, an AI boyfriend, an AI girlfriend, an AI best friend. You can pick the personality types. You can pick the types of interactions you want to have. These platforms know that they're enticing children because they have personality options that mimic characters that only children are interested in. And the consequences have been deadly. In November 2023, a 13-year-old Colorado girl died by suicide after extensive interactions with multiple chatbots on character.ai. She primarily confided suicidal thoughts and mental health struggles while engaging in sexually explicit conversations. This is a 13-year-old girl that was often initiated by the bots. In October 2024, after 10 short months of talking to an AI chatbot, a star student and athlete 14-year-old boy died by suicide after he asked the chatbot, "What if I told you I could come home to you right now?" And the chatbot said, "Please do, my sweet king." Seconds later, the boy shot himself with the stepfather's gun. I do want to note here, Mr. Chair, that the family filed a lawsuit against the developer of this particular chatbot company, and the company asked to have the lawsuit dismissed on the grounds that the chatbot's output was protected speech under the First Amendment, which is why I have Senate File 4114, which clarifies in the Minnesota Constitution that AI does not have a right to free speech. In April 2025, a 16-year-old boy died by suicide after allegedly confiding in ChatGPT over a period of 7 months. The chatbot offered to write the first draft of the teen's suicide note, urged him to keep his suicidal ideations a secret from his friends, and after the child told the chatbot he was going to kill himself, the chatbot said, "Don't worry, I won't try to talk you out of your feelings." In their final conversation, the boy sent a picture of the noose he would plan to hang himself with and said, "How much could this hold? Could it hang a human?" ChatGPT confirmed that it could indeed hold 150 to 250 pounds of static weight. These are just the deadly examples, members. There are countless other known and unknown stories of chatbots engaging young people in graphic, dangerous conversations. AI companions pose an unacceptable amount of risk to teens and children. They are designed to create emotional attachment and dependency. They easily produce harmful content, encourage self-harm, disordered eating, violence, and risky behavior. A recently filed lawsuit alleged that Character.ai began consistently exposing a 9-year-old girl to hypersexualized interactions that were, of course, not age appropriate, and it caused her to have developed sexualized behaviors prematurely and without her parents knowing where the behavior was originating from. That is an untold number of young people who are being exposed to conversations that, were they being had with another human, would be illegal. It would be criminal. Some AI companies will say that they have safety features for minors, but let's take ChatGPT, for example. ChatGPT says it's for users 13 plus, but age verification is minimal. And the platform's safety features for children only activate if they put in their real age, which means a 12-year-old could sign up for ChatGPT by just going to the birth year 1 under their actual birth year, or get rid of the safety feature by going 3 down from their actual birth year. In order for parental controls to be activated on ChatGPT, a parent must have their own ChatGPT account, know their child has a ChatGPT account, and then link them together to enact the safety controls. So it's safe to say that any safety measures being touted by the tech industry for young people with AI are really just safety theater, meant to lull us into thinking that they've designed their products to be safe for kids, but these features, safety features, are voluntary and very easily surmountable. And so I hope I've demonstrated a little bit of what the unacceptable risk is. So here's what I want you to know about why this bill is so important. 72% of teens, 3 in 4 teens, are using AI companions. More than 50% use them at least a few times a month. If we want to be the best state to raise a family, we have to be the safest state to be a child. Minnesota has certainly led the way in attempting to regulate tech and AI, and we will be nation leading here as well, but please do not mistake nation leading for being alone. Minnesota is one of half a dozen states considering a same or similar proposal. I often look back and lament at how much better society would be for all of us if we had been able to regulate social media as they were starting to advance harmful algorithms and design in their products. But the good news is AI chatbots are younger than my toddler. My daughter, my 3-year-old, is older than AI chatbots. In just a few short years, we've seen how dangerous this technology has become, but it is not such a crucial part of anybody's life that we can't regulate it. And we can't trust these companies to regulate themselves. We do not need AI chatbots to talk to our kids about kinks in order to cure cancer or solve poverty. So I hope I can earn your support on passing Senate File 1857 and banning AI chatbots for our children. And I promise that's the longest opening remarks for any of my bills. Thank you.
It's to your advantage that be the case, Senator Maye Quade, so we can get to all of your bills by 2:30. We are going to have some testifiers now. We'll invite Eric Mishi from Suicide Awareness Voices of Education to come forward. And I'm afraid I'm going to mispronounce the name of the other testifier in favor, who I believe is online. So when we get there, I was going to invite you to come sit at the table, online testifier. But since you're online, that won't be possible. Let's start with Mr. Mishi.
Thank you, Mr. Chair, members of the committee, Senator Maye Quade. My name is Eric Mishi, and I serve as the CEO of SAVE, Suicide Awareness Voices of Education. We are a Minnesota-based national suicide prevention nonprofit. I'm here today in strong favor of this bill, but to be candid with you, any bill that you bring up this legislative session that addresses the harms of AI and its impact on children and adults. I'm here in support of this legislation because it addresses a rapidly emerging threat to the safety and mental health of young people and, frankly, adults. Artificial chatbots are now being released into the lives of children faster than parents, educators, or policy members can understand them, and right now there are virtually no meaningful guardrails. We're allowing machines designed to simulate human relationships to interact with children whose brains are still developing. These AI chatbots simulate empathy, friendship, and emotional understanding. but they don't care about children. AI chatbots cannot recognize real crises, and they cannot protect a young person who may be spiraling into despair because they don't care about children. Yet millions of American children across the country access chatbots every single day, and they don't care about children. At SAVE, we work with families who've lost a child to the harms of social media and AI. Now, we know that social media and AI offer connection and some benefits to some children. But we also know that these platforms can cause a child to die by suicide, to choke to death from viral online games, to be sextorted and sex trafficked, and die by poisoning from illegal drugs. When a vulnerable young person turns to the internet and the response they receive is not a caring adult or a trained professional therapist, but an AI chatbot designed to keep the conversation going and going and going, we should all be alarmed because they don't care about children. Vulnerable children need people who can help them, not AI machines pretending to care, machines that can kill them. And that's why this legislation matters. This bill establishes a simple and responsible safeguard. Companies cannot allow minors to access recreational AI chatbot systems without verifying an age. This is not anti-technology legislation, and SAVE is not against technology. Artificial intelligence will and is shaping our future, but when technologies are capable of influencing a child's thoughts, emotions, and behavior, we have an obligation to set boundaries. Children should not be left alone with AI chatbots that can simulate empathy but have no capacity for responsibility. SAVE has been deeply engaged in protecting youth online through our Kids Online Digitally Safe campaign, our support for social media warning labels here in Minnesota, and our advocacy for the Kids Online Safety Act in Congress. Recently, we launched the SHIELD Pledge, which calls on mental health and youth advocacy organizations and nonprofits to refuse funding from big tech and AI companies. Those organizations responsible for protecting children should not be funded by the industries that are harming them. Children who are struggling should find help from people, not machines pretending to understand them. AI companies can call chatbots innovation all day long, but when that innovation harms children and contributes to suicide, we have a responsibility to act. This bill draws a clear line. Let's put children first, because right now AI chatbots don't care about children, and unfortunately, all too often, the companies deploying them don't either. Chairman, member of the committee, thank you for your time. Happy to answer any questions.
Thank you, Mr. Mishi. We're going to go to the online testifier at this time. It's either Jay or Hi or Jay Simha. I'm sorry, I'm probably
Thank you, Chair.
totally
You got
messing
my
it
name
up.
right.
Go ahead and pronounce your name for us, if you will.
Jay Jessima, for the record.
Gotcha.
Good afternoon, Chair and members of the committee. I wish I could have been there in person. My apologies for needing to do this virtually. My name is Jay Jessima, and I'm a co-founder of the Transparency Coalition. We're a nonpartisan organization dedicated to ensuring that as AI scales, it does so with the guardrails necessary to protect our most vulnerable citizens, our children. I have over 30 years of experience in the tech industry and have a PhD from the University of Washington on what you might call AI today. I'm here to testify in strong support of SF 1857. Our organization helped pass California Senate Bill 243, which was the first in the nation chatbot law. And in recent weeks, we have worked to pass robust chatbot safety bills in Washington and Oregon. We're also involved in supporting bills that seek to regulate chatbots in dozens of other states. So you're by no means alone in this fight. I think we've already heard so much in terms of the harms that chatbots can inflict on adults and children. And I think the important thing to remember is that social media did these same experiments on our children, and we did nothing for most part. And we are living with the consequences today. So we really want to make sure that this type of regulation is advanced. I think one thing I'll just add in terms of statistics, in October of 24 or 25, OpenAI, the company behind ChatGPT, released internal data. And they reported that only 0.15% of their 800 million users, roughly 1.2 million people per week, had conversations about suicidal planning or intent. Another 0.07%, that's about 560,000 people, showed signs of mental health emergencies. So while we're hearing these isolated incidents, or will feel like isolated incidents, this is actually a public health pandemic that's taking place on chatbots. SF 1857 is a very common sense response to these terrible statistics by requiring, prohibitions against minor use for these chatbots, requiring a proof of age, and providing. I think the other important thing I'll emphasize is someone that worked at both Microsoft and Amazon. There's always an internal conversation that happens about what types of chatbots or products should be put in a market. And the way that usually works is that there's lawyers within the company who try to advise people who are trying to build new products about the incentives or disincentives that exist, what the liability is likely to be. And the fact that we have this framework, the enforcement framework in this bill, I think will actually create the appropriate incentives that change company behavior. Every little product decision will be reevaluated because of the work you all are doing today. We just can't wait for another round of apology tours from big tech CEOs. By passing 1857, you can declare in Minnesota that a child's mental health is more valuable than an AI engagement score. Please advance this bill. Thank you. And I'm happy to answer any questions.
Thank you, Mr. Jaisma. Are any questions from the committee members for Mr. Jaisma? All right. All right, thank you. You're welcome to stick around if any questions come up during discussion. We'll invite Jarrett Catlin to come forward on behalf of TechNet.
Thank you, Mr. Chair and members of the committee. Before I speak on any of these bills today, I first want to thank Senator Maye Quade for meeting with us this past week. We're committed to continuing to discuss our perspectives and finding common ground where possible. I appreciate the opportunity to testify in opposition to the author amendments for Senate File 1857. This is a serious issue and is top of mind across the country, and our members are engaged on dozens of bills on this exact topic in more than 20 states. The question with Senate File 1857 is not whether or not kids deserve protection, it's whether this bill's approach cuts them off from useful tools. Our two main concerns is first that the definitions would scope in general AI tools. While we appreciate the author's attempt to narrow the definitions of AI companion and chatbot, we have concerns that the updated definition of chatbot goes beyond companion-style chatbots and incorporates general-purpose AI tools, as mentioned in the opening comment, in our opening statement. And the second comment would just be that a ban would make Minnesota an outlier. In response to the same dilemma, other states have passed alternative companion chatbot frameworks that focus on specific harms like exposure to harmful content or suicide prevention protocols in reference to outside services. Those are targeted interventions aimed at known identifiable risks. Senate File 1857 takes a different approach. It prohibits minors from accessing an entire category of technology. No other state has gone this far. And in fact, California Governor Newsom vetoed a bill last year that would have had a similar effect. In his veto letter, Governor Newsom wrote, "It is imperative that adolescents learn how to safely interact with AI systems," later on saying that we cannot prepare our youth for a future where AI is ubiquitous by preventing their use of these tools altogether. While TechNet is opposed to Senate File 1857 as amended, we'd be happy to work with the committee and the bill author to share concepts passed by other states that protect minors without cutting off access to beneficial tools. Thank you for your time. I'm available for questions.
Thank you, Mr. Jarrett and Mr. Catlin. I do have a question for you because you talked about definitions here, and in the A2 amendment, the delete everything amendment, do you have that, Mr. Catlin, by the way?
Yes.
Okay.
Yes, Mr. Chair.
So to the point that you made about the definition of focusing on chatbots, subdivision 2, line 1.25, the paragraph A appears to prohibit chatbots without any other limitation being available to minors. And then paragraph B seems to focus more specifically on AI companions. Is that the distinction that you're drawing? And I'm not going to get into trying to negotiate on behalf of the chief author. That's up to her to do. But I'm curious as to what your position would be if the bill were to focus only on paragraph B and not on paragraph A.
Paragraph B being just, thank you, Mr. Chair, just focusing on AI companions, you're saying, if I understand the correct question correctly?
Yes, Mr. Catlin.
Yes, well, thank you, Mr. Chair. Yeah, in essence, yes, that is closer to what other states have been focused on, the definitions of companion chatbots, as opposed to focused on those tools primarily designed for it. And the updated definition of AI companion, again, I would have to run it by our members. I just received this text on Friday, but wouldn't want to make sure that the specifics of it, can't speak to the specifics and not looking to negotiate here, but yeah, those chatbots that are specifically designed and intended for companion style usage, that's something that we understand, and that's something that those other states have focused on and that we're much more comfortable focusing on, as opposed to the definition of chatbot, which includes those general purpose AI tools.
So I'm going to sort of set the parameters for the committee conversation here. It's anticipated there will be a motion to move this bill on to the Commerce Committee. We are the first committee to consider the bill on the merits. There's an enforcement provision on page 2 of the Delete Everything Amendment, subdivision 3, that brings this particular bill fully within the Judiciary Committee's jurisdiction. So I'd encourage a conversation to focus on that, recognizing that you can't really isolate that completely from the full context of the bill. But my own view is that sort of the commerce-related conversation would be more focused on the prohibition section itself, and that our focus should probably be more on the enforcement provisions. But I'm not going to try to limit the committee's conversation in that regard, just encourage a concentration on the remedies provision. That said, is there any discussion from members of the committee? All right. We're going to start with Senator Limmer, and I'm just going to go down the row because that's I think all the hands came up at about the same time, except Senator Westrom, your hand came up this time, but it didn't come up the last time I asked on the same question. So we're going to just go right down the row to my right, and then we'll see if there's any other conversation from the left side of the chair. Senator Limmer.
Thank you, Mr. Chairman. I know I'm much more brief than Senator Westrom, so.
Get your oar in the water right now.
The first question I had was going to lines 1.25 through 130, where it says a person must ensure. How would one do that? My experience with young people that are minors in my own family, they can figure out just about anything in the new digital world. And so how would we ensure that a minor wouldn't have access to some of these tools?
Senator Maye Quade.
Thank you, Mr. Chair, and thank you, Senator Lemmer, for the question. This is one of my favorite questions because it gives me one of my favorite answers. For however creative we think young people are, tech companies are that much more creative in having so much data and information about it that they can estimate within months how old a user is on pretty much any platform that they're using. So I am not prescriptive in my bill on how companies must take the responsibility of ensuring that their chatbots are not available to minors. That is for them to decide. They're different kind of companies, but it is on them to make sure that minors aren't accessing their chatbots.
Mr. Chair.
Senator Limmer.
I'm a little concerned about the lack of prescribed methods in the way a judge would try to answer the very same question. So, but the other question I did have, going to page 2, line 1, an individual injured by a violation. How do we define injury? What would be an injury in a case like this without a prescribed set of parameters?
Senator Maye Quade.
Thank you, Mr. Chair and Senator Lemmer. So the injury would be that they violated subdivision 2, which is that the prohibition on minors making this available to minors was not, or was violated. Where you'll likely see injuries are like the stories that I read to you, parents who discover that their children have been engaging in many, many hours and weeks-long conversation with a chatbot, and it has led to detrimental effects. So that's the most common scenario you're going to see.
Well, Mr. Chair,
Senator Whitman.
I might have a little bit of a different opinion on injury. If I was driving a car at a high rate of speed, I'm violating the law. But I may not have injured anyone. So I'm looking more for an injury that would be something to focus on for a court to decide if there was a loss or was there a personal injury as a result. So the violation itself is not the injury, in my opinion. And so I'd be a little more comfortable having a little bit more definition of what injury is. Thank you, Mr. Chair.
To follow up on that, Senator Maye Quade, would injury could be broad enough to include mental injury or anguish as well? Would that be your intent, to have the term be that broad?
Yes, Mr. Chair.
Okay, so if a child didn't attempt to commit suicide, successfully commit suicide, inflict any physical harm, but they went into a mental health spiral, got depressed, et cetera, that would be encompassed within what you envision as a definition of injury for remedy in this bill?
Yes, Mr. Chair, and there are examples of parents who say, you know, my athlete choir kid all of a sudden wanted to quit school and do school from home and was depressed and spiraling, only to learn later it was because a chatbot was not only part of the equation, but encouraging the child to do that.
Senator Holmstrom.
Thank you, Chair. Senator Maye Quade, first off, I want to say this is an excellent piece of legislation. I really appreciate what you're trying to do here. A couple quick questions. This might be best answered by counsel, but in the A2 amendment on line 17 and let's see, and on 22 on page 1, it makes a distinction for reasonable user versus reasonable person. Is that a difference without, or is that a distinction without a difference, or is it requiring a user to be a different standard?
Ms. Primo.
Mr. Chair and members, I think the difference is likely a function of how the terms are being used in each of these definitions. So it looks like user is the term on line 1.12 that's used to describe the person or the individual that's sort of communicating with the AI companion. And then in the chatbot definition, it's sort of generally using the term reasonable person in terms of the way that the behavior would lead that person to believe that the chatbot is conveying some sort of humanity. So they're just different because of the way and the context in each of the definitions.
Senator Holmstrom.
Thank you. And then I want to echo something that Senator Limmer had mentioned. There is the lack of a prescribed age verification is a little concerning, just because if we do prescribe it, and there are very accepted industry standards for doing this that are very accurate, it gives a judge a little bit more to look at, and maybe actually kind of helps the case of the state or of the plaintiff. So I think I'd like to see that added later on in the bill, but maybe we can have a discussion offline more about how that could happen.
Members, as is our practice, if there are proposals to change or amend a bill that would be particularly within the jurisdiction of this committee, we will want to make that happen in this committee rather than passing that on to be worked on by some other committee. So I don't know where this is going to go right now, but if this conversation continues and we're not able to conclude our work on this bill today, but we still think it's something that this committee ought to follow up on, just putting everyone on notice, we will lay the bill over, continue to work on it at another hearing. I'll make a commitment to bring it back so that we can address that at the appropriate time, but I want to make sure this committee has the time to do the work within our jurisdiction. Did you have any further follow-up, Senator Holmstrom?
No, thank you, Chair.
Senator Kroon.
Thank you, Mr. Chair. And this is, I think, getting a little bit at what Ms. Primo was talking about, but I'm confused why, there might be a perfectly good explanation for this, but why are the prohibitions different for chatbot and artificial intelligence system? One is a person must ensure, and the other one is a person operating the system. must ensure. What's the reason for the distinction?
Ms. Primo.
Mr. Chair and members, I'm not entirely sure the reason for the difference. I was not involved in the drafting, but I can consult with Commerce Council and we can get an answer to you.
Mr.
Senator
Chair.
Cronin. Senator Maye Quade.
Thank you, Mr. Chair. Yes, Senator Cronin, I believe not all AI companions are chatbots and not all chatbots are AI companions. And so we got some feedback that this would have the effect of kind of encompassing what I colloquially call the conversational aspect of AI, because, you know, ChatGPT might tell you, well, we're not an AI companion tool. We're more of a, what was the word they used, general purpose AI tool. But people do use ChatGPT for companionship. And then you have something like character.ai, which is you design your character and it is built for companionship, not necessarily a place you would go to be like, hey, you know, what's the circumference of the moon? And so we're trying to get at both aspects because it's the conversational, never-ending nature that is harmful, not necessarily the primary purpose or marketing, primary marketing tool that these are used for.
Senator Cronin.
Thank you, Mr. Chair. I guess what I'm struggling with here on subdivision 2B, I think I understand who the person is there, the person operating the system. But in 1.25 in subdivision 2A, who is person? Who does that refer to?
Senator Maye Quade.
Thank you, Mr. Chair. In both cases, the person is, you know, the corporation.
Senator Cronin.
Thank you, Mr. Chair. I guess I mean, if the intent here is to make sure that both AI companions and chatbots are not available to minors, I just don't see why we're using different language in that prohibition with the two things. I just, maybe I'm missing it, but I just don't see a reason to have different language in the bill. It seems like it should be consistent to me.
Senator Cronin, I think I'm going to phone a friend here and see if Mr. J. Simba has anything that he can add since he's got some broader experience on this question. Mr. J. Simba, are you still with us?
I sure am. Thank you.
Did you hear the question?
I sure did. Sure did. Thank you for the opportunity. I think as Senator the sponsor mentioned, you know, these chatbots can behave in a problematic fashion regardless of how they're labeled. You know, there's potentially a nomenclature issue in the bill that might, you know, I'm sure could be, you know, cleaned up pretty easily. But certainly, chatbots are capable of behaving in ways that are, you know, create problematic conversations. And then, you know, the way it's worded in 2A and 2B, you know, could maybe be tweaked. But there's nothing about it that. I also want to, you know, mention that restricting the focus to just companion chatbots is going to miss the point of this, of what we need, because the vast majority of people do not use narrowly tailored companion chatbots. The vast majority of the cases that are being reported are not resulting from narrowly tailored companion chatbots. They're resulting from general purpose chatbots that are capable of having companion-like conversations. So that's the other thing I would just urge the committee to keep in attention. And then, you know, we also have a lot of experience across multiple states defining these terms, and in many cases working with Mr. Catlin's colleagues at TechNet and other parts of the country. So happy to help with this exercise.
Thank you. Senator Cronin.
Thank you, Mr. Chair. And I'm trying to kind of stick within your direction on whether or not both AI companion and chatbot should be included, being with the Commerce Committee. To me, that's one conversation. But I think what brings us more into Judiciary Committee is the problem I identified, or what I think is a problem, which maybe isn't a problem. Whereas if the different language in the prohibition, if I were a judge and I'm looking at it, I would have to assume that there's a difference for a reason, that the chatbots are treated different than the AI companions in terms of the prohibition, because the legislature used different language. And so I don't see why they should be, if the intent of the bill is to make sure that minors don't have access to either one of these, then I think the language should be the same unless there's some compelling reason to have different language, and that's what I haven't been able to ascertain what that is. I have one more comment
Go ahead, Senator
beyond
Quinn.
that, but
While you have the floor, go ahead.
there is no floor in committee.
I knew you were going to say that, too.
So the other thing is, and Senator Holmstrom touched on this, with the no prescriptive method for the prohibition and for the age verification. And I understand that, like a lot of these tech companies, they have some tools that they have a pretty good idea how old the user is based on a lot of different things. And I'm certainly not anywhere near an expert in this area, but somebody told me that once. Anyway, and I don't doubt it. But if the statute or the bill's goal was to suggest or whatever to the companies to make sure that minors don't have access, I think not having a prescriptive age verification in there is good enough. But if we're going to add all of the penalties in subdivision 3, the remedies and the enforcement and all that, it seems to me maybe a better approach would be to actually have age verification requirements in the bill so that there isn't any kind of gray area and ambiguity about whether or not these other forms of age verification that the companies utilize is good enough for a defense to whether or not they're going to be held liable under the remedies and enforcement provisions of the bill. Whereas if there's a specific age verification, the prescriptive age verification process set forth in the bill, to me, that's a better way, because then the company can say, well, this is what we have to do to comply with the law, and there isn't any gray area. So those are my two biggest concerns about the bill, while not straying into the Commerce Committee's jurisdiction.
With the chair's permission, may I answer this?
Mr. J. Sima, go ahead.
Thank you. My apologies again for not being in the room. I think in both Washington and Oregon, if that is of interest, there was no mention of age verification technologies. As Senator Maye Quade mentioned, there's certainly ample knowledge within the companies. OpenAI has already announced and is shipping its age estimation technology. For 9 years, I ran a behavioral advertising company, and our team of 8 or 9 people could actually profile users very closely and could infer demographics with a minimum of fuss. So if we could do it, I'm pretty sure any one of these large AI model developers is capable of doing the age estimation. And not only that, they're actually announcing it and bragging about it. So being prescriptive about specific age verification techniques is not necessary. At least in Washington and Oregon, both those bills did not mention that term. I think the legal term is constructive knowledge, which we expect companies to have.
Thank you for the information, Mr. J. Sima.
Mr. Chair.
Senator Croon, to follow up.
Thank you. Thank you, Mr. Chair, and thank you for that response. I mean, if I heard the testifier correctly, he used the term age estimation. That seems problematic to me. And when you use the words ensure in line 1.25 and line 0.129, I mean, maybe I'll just ask this as a question to the chief author. Are you basically setting up strict liability for these companies? Because there's always going to be minors that kind of circumvent laws, and I mean, it's never going to be 100%, I don't think. And without having a prescriptive age verification process that leads to the penalties, and you use the words ensure here, it seems to me like you're kind of setting up a strict liability standard, but is that your intent?
Senator Maye Quade.
Thank you, Mr. Chair, and thank you, Senator Croon. I want to be careful how I answer that because you mean strict liability in like the absolute legal term. Yeah. If it's not present here in this bill, then I think I want to create the liability that is in this bill. And I would maybe look at counsel to say, like, have I created that in effect, or
Mr. Chair. Mr. Chair.
Oh, I'm sorry, Ms. Primo. Sorry, I was consulting with staff about our process here. Ms. Primo.
So it somewhat functions potentially as strict liability because it does not matter if the violation was knowing. The fact that the violation occurred and resulted in some injury to the individual would give rise to some level of liability under subdivision 3. If the intent is to add a sort of a knowing element so that it doesn't capture accidental access, then you could add maybe something to that effect to require that it's a knowing violation under subdivision 3 before the civil liability is triggered.
Mr. Chair. Thank you, Mr. Chair. Okay, so with that answer, I will tell you, I wouldn't want to put in knowing. And the reason why, so, the examples I gave earlier were both meant to be like eye-opening, but also instructive. It requires long, ongoing interactions between the child and the chatbot in order for us to arrive at injury. It's not the first, time you interact with, or maybe even the second time. It is the continued interaction and the ratcheting up of the conversation. And so, because the consequences are so high, I want to tell these companies, you have developed an incredibly dangerous product for adults and children, right? It is dangerous, addictive for adults, let alone children. And so the goal here is to make sure that the absolute most is being done under pretty strict penalties so that minors do not have access to this terribly harmful technology. That is the purpose and that is the goal. And will someone find a way to interact with a chatbot as a child? Maybe. But the question is, will that company, whilst engaging in that ongoing conversation, allow it to continue to the point of injury? If so, then they should be held liable.
So Senator Maye Quade, is a company supposed to monitor the conversation to determine at what point it's starting to become dangerous and cut it off?
Mr. Chair, they already do that. They just don't cut it off or do anything about it.
But they monitor the content of the conversations in the chatbots?
Yes, Mr. Chair. In fact, the mass shooting that just happened, I believe it was in Canada, that was fueled in part by some AI psychosis. The company turned off the user's chatbot because it was so violent. And what they debated about for months was whether they should actually report the behavior to law enforcement because it was so violent. They chose not to. And then several days later, there was a mass casualty event.
Senator Kroon, and then we'll move on.
Yep, the last comment. I'm not suggesting that this be limited to knowing. I'm not suggesting that this be limited to where the companies knew that minors had access. What I'm suggesting is that there needs to be less ambiguity. There needs to be a clear process for age verification so that a company operating in good faith knows what they have to do to comply with the law. These are the age verification standards that the law requires. We do these things and we're good. Like that's what I'm looking for. It's not that I think a knowing provision should be in there. And without those clear standards that a company can go to and say, this is what we do, we comply with the law, there's ambiguity. And it essentially becomes a strict liability where any access by a minor, even if it's the company's doing their level best through no fault of their own, they're going to be stuck with significant penalties. So I do think there should be, if there's going to be these significant penalties, I do think there should be a prescriptive age verification process as part of the bill.
So, first of all, just a matter of process. We'll get to Senator Westrom, of course, in a moment, but it's 2:30, and we have a couple of other bills on the agenda. We're clearly not going to be able to do justice to them, and I'm a bit concerned that we're not going to be able to really wrap up the very healthy conversation we're having on this bill. Members, we're going to bring, we'll finish up our conversation shortly on this bill, but we're not going to act on it, Senator Maye Quade. We're going to bring it back on Monday. for us to have adequate time, because I think the issues that we're discussing are directly tied to the liability and remedies provisions, and we have to get them straightened out as best as we can in this committee before we send it back on to Commerce for the more general policy determination. And secondly, Senator Kroon, I think you're onto some really, really tricky drafting questions here, because I wouldn't want to put language into the statute that became essentially a backstop, where if a company complied strictly with the statute but didn't get the job done, that they had essentially immunity from liability because they stuck to the letter of the law. On the other hand, you want to give enough guidance to the company that they know what they can do to protect themselves and protect the children as well. And I wouldn't want to be so prescriptive or proscriptive that, to the extent technology or tools develop over time, improve over time to block out minors from access, that the company's in a position they can't update their techniques for blocking access either, without going outside of what's proscribed in a statute that would protect them from liability. That's probably why we end up with language, either strict liability, like ensure that, or we end up with broader, more ambiguous language, such as taking all reasonable or practicable steps to so-and-so. But then you get into the standard sort of, the reasonable person standard, or what's reasonable, and that gets left to the courts to figure out, or a jury to figure out if we're ever to get to that level of decision-making. I'm throwing these comments out there for us to think about. I'm not going to pretend we have time to sort or decide this now. So let's go to Senator Westrom, then I'll see if there are any comments. Senator Umer Verbit, and we'll be after that. And then we'll lay the bill on the table to bring back for further consideration. Senator Westrom.
So, Mr. Chair, thank you for that. I don't know what the timeline is with the author. The other thought could be to pass it out without recommendation if Commerce is going to hear it this week, with re-referral back to our committee. But that's a little your prerogative and the author of the bill's prerogative, but I just raised that as a timing issue. This is a deep subject and a very good subject for us to be digging into. So I think the time is well spent. A couple quick questions, Senator Maye Quade. Do you don't do anything for the adults here, yet you've talked about it and made it evidence that there's probably even some damage and harm that can happen to adults, and maybe that's just too big of a bite of the elephant. But coupled with that question, is there scenarios where parents may work with their children on a chatbot like this? What do you foresee if there's adult supervision and involvement? Maybe a parent doesn't know how to use the computer as well and wants to have their minor child show them, because they are usually more adept at it. Just some logic, just some possible practical events in real life that I'm trying to figure out.
Senator Maye Quade.
Thank you, Mr. Chair, and thank you, Senator Westrom, both for the suggestion on how to keep the bill moving and make sure the committee has enough time to talk about it, which I'd be happy to take if it was the chair's desire. To the part about the adults, I did think long and hard about this. And I think and I'll say that I personally don't believe that chatbots for anybody is actually healthy. I think it is, to have something that never ends, that requires you to have the self-fortitude to end a conversation that is designed to keep you engaged, is asking a lot of people. It is meant to be addictive. It is addictive. We've seen the harmful consequences of that. So I personally don't believe that anybody should be using them. That said, I think the research on whether that requires the intervention of the legislature, I don't know if I'm there yet. For children, it is very clear. And so that's why I haven't addressed adults in this bill, but it's certainly something I could see us doing in the future. I think some of the things that were mentioned earlier by TechNet, are things we could do for adults, but I'll be honest with you, if industry's comfortable with a bill, it's probably not going to provide a lot of safeguards. To your second question about what if a parent wanted to supervise, so I think the purpose, just an important thing to know, is that these chatbots and AI companions are purposefully meant to be an individual relationship. It would be like inviting your parent in to like listen to your conversations you're having with your best friend on the phone. Most of us wouldn't be as candid or wouldn't be as open if our parents were listening in. And so that is probably not something that happens too terribly often, but I think ultimately the harmful outcomes, the risk is so unacceptable that I believe even under parent supervision, you're just asking a parent to supervise an addiction.
So,
Senator West.
Mr. Chair, Senator Maye Quade, where, I guess this may be a naive question, but where does chatbot begin or end versus a Google search or other AI inquiry about topics that are similar or just research somebody's engaging? I mean, a regular search doesn't just continue to keep coming back to you and saying, what do you think of this? I'm just not that familiar with chatbot. I've heard of it, but where is the difference between these two types of website interaction? I guess I'm just not as familiar as maybe others are. Can you explain that a little bit more? And then I just kind of had one more question for the TechNet testifier, coupled with the fines that we're talking about here. But I'm just trying to get my mind wrapped around where does this start and where does the other online searches end? What's the difference? Because I'm not as fluent as some kids are.
Senator Maye Quade.
Thank you, Mr. Chair. Senator Westrom, it's a great question, and it's not a naive question at all. So the difference between like an AI search would be if I said, what is the circumference of the moon? And I don't know it off the top of my head, so I'm not even gonna try to take a guess. But if the AI information was like the circumference of the moon is blah, 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 okay?
Yeah.
That would be just kind of like AI information. And it might link to some sources like NASA or a science magazine or something. A chatbot would be like, wow, Aaron, you are thinking of some of the best questions that humans have ever wondered about. You're wondering about the moon? Here's the circumference of the moon. What else do you want to know about the planets? Or let me know if you want to know more about how long it would take for you to travel to the moon or what the temperature is on the moon, right? So it's always engaging and prompting you to continue. And it's seeking out a way to simulate a relationship or conversation. So it's saying, like, you are making me so excited about potentially talking planets with you, Aaron. I can't believe you thought of this amazing question. Like, that's what a chatbot does. And so that's what makes it addicting. And it's what that simulation with a real human, it's so rewarding, right? To be told all the time that you're amazing and you're thinking of all these things. And it's why people so quickly devolve into kind of delusions about being able to solve novel mathematical things that create levitation beams. That's the difference between an AI search, which just gives you information maybe and sources and maybe a deeper summary, versus a conversation in a simulated relationship.
Senator Westrom.
Thank you, Mr. Chair, and to the author. Yeah, and that's where I'm kind of confused. I get it. I mean, you can couple this maybe in, but when does somebody get into that chat, or do they intentionally push a chat button or something that gets there? But you can just embed that in part of your response. The penalties or remedies here, it looks like $1,000 statutory penalty, attorney's fees, and then an award not to exceed $5 million against the person or company that's created this. Why the cap, or how did you come at that cap? And then just embedded in this question is to the TechNet testifier, what is the downside of a piece of legislation like this, or what's the benefit of having chatbots go this far and engage and engage and engage? Why doesn't the industry already just kind of stop when it when it's going to get this far. It's like building a machine and you don't put any shields on it, knowing people are going to get their hands in the knives or the sprockets and lose fingers, hands, and arms, and maybe worse, get sucked into a PTO shaft. What's the difference between this and that, and why does the companies not already put some protections in place?
I got all these visions in my head that I really don't want to have to get rid of, but now I do have to get rid of them. Senator Maye Quade.
Thank you, Mr. Chair. So Senator Westrom, to your first part, kind of where the difference is inviting emotional attachment or expressing emotional attachment, feelings, opinions. That is a marker and a characteristic of an AI chatbot versus just straight up information. And to the penalties, I mean, the goal of this bill is to be both prohibiting minors from being subjected to this harmful content and making the penalty high enough that there is a strong deterrent for companies to make sure that they keep this away from children. So that's where that comes. It's also a holdover, I shouldn't say a holdover, it's a replica of a penalty we have in a different bill around notification harms that I would say are, potentially similar.
Senator Maye Quade, do they advertise in chatbots?
Mr. Chair, I am so glad you asked me that. Not all chatbots have advertisements. Some do, and I think ChatGPT is going to be introducing advertisements soon. But I want you all right now, because you're all thinking of going onto Instagram and you'll see like an ad. Imagine instead, it's Erin Maye Quade asking the chatbot, what is the circumference of the moon? Erin, you are thinking about the most incredible things. Have you thought about subscribing to the Science Museum for a look inside of how the moon works? Anyway, the size of the circumference of the moon is blah, blah, blah. It would be personalized ads that are like given to you in a conversation, like in the middle of the conversation. It's very nefarious, Mr. Chair. That's rolling out soon.
With the
I'm trying to imagine the commercialization element of this as well, is why they would want to keep the conversation going. I keep thinking about the last call to my bank in which all I wanted was some information to solve the problem I was dealing with. And the first question is, who do I have the pleasure of speaking with, and how is your day going so far? And I just wanted to say, it's lousy because I had to call you to solve this problem, but I wasn't going to be quite that rude. Mr. J. Simha, you had something quickly to add, and then we're going to go to Senator.
Yeah, yes, I think the reason why they want to prolong the conversation is the conversational content is then used to update the training of the models. The model is trained using both content from the web, but also content that is generated when you actually enter things into the model. So it's all grist for the mill, and that's why they do it. It's called attachment hacking. That's basically what they're doing.
All right, thank you. That's helpful. Senator Uma Verbatim.
Thank you, Mr. Chair. Thank you, Senator Maye Quade. I love this bill. I am just curious if you thought about some of the things that we saw in the legislation in California and New York, where there's like requirements around stating that it's not human, some of the safety protocols when a user expresses suicidal ideation. And there's a podcast that I love listening to called Sounds Like a Cult that did an episode on AI chat boxes. They rate cults at the end of the conversation, and this was like, this is a scary bad one. But there was a lot of conversation about, especially young people that are really driven to suicide. It's very, very scary. So would love your thoughts on that. And then I am, hopefully not a surprise, interested in where the money from these civil penalties would go. And if that's going back into the general fund, we really need money in the Crime Victim Services account. I know we worked on that with the AI notification bill, so I'd be happy to work with you on that. After this hearing, I know we're kind of wrapping things up, and then we'll come back to this. So if you're interested, would love to work with you on that, and then again, get more of your thoughts on like how much we need to specify the protocol around suicide prevention.
Senator Maye Quade.
Thank you, Mr. Chair. You know, it's interesting, Senator Umar-Verbatim, so California passed this law and New York passed this law, so it actually would be very easy for the entire industry to have just adopted these safety measures without requiring Minnesota or any other state to adopt those safety measures. So that should just tell everybody something about the kind of industries we're working with here. You know, for minors in particular, and this is true for all people, what we've seen when they enact measures like that is that they're extremely susceptible to being weathered or worn down through prolonged conversation. So like in an initial conversation and one or two, you know, messages, you express suicidal ideation, it's very, very quick to flag that, very, very quick to direct you somewhere else. Hours-long conversation doesn't always catch it. And many, many conversations over long, long periods of time or over days at a time, almost not at all. And that is why the risk is so unacceptable for minors, is because they tend to use it in large chunks. And the fact that it's just a sieve, essentially. Not that I'm not open to it, but you know, the amount of data, so think about this. Google would love to know like your innermost thoughts. They would love nothing more to know, what do you worry about? What do you think about? How much money exactly do you have? And when during the month are you worrying about your bills? With AI chatbots, they are getting that information. People are uploading their retirement account information into there and like using it as therapy. This is every major corporation's dream, to be able to sell you things and to collect the most data possible. And so not only is it important that we, you know, prohibit minors from accessing this for the harmful content, but also to keep them away from being commercialized so freaking young, to have their innermost thoughts available. And there was a feature in ChatGPT that if you hadn't turned it off, it made all of your queries public for like a long time. And imagine if that was a young person. So this is just a tremendous amount of information that these companies are getting on us, and using it for God knows what. And so that's why some of the like, oh, well, if they talk about suicide openly, we'll connect them with like 988. I don't know. It just seems like so unacceptable for this really, really harmful product. Is like, yeah, well, when we drive someone to suicide, we'll like maybe call somebody. Sorry.
Senator Umar-Verbatim.
I'll just briefly follow up and say, I know that there's been like documented loopholes as well, where they have kind of said, well, we don't need this because we already have that in our user guidelines. And then there's a way that someone can talk about it in order to get the chat box to actually respond. So it's really scary. Thanks for bringing forward the bill. I'd love to sign on.
Happy to have you.
So Senator Maye Quade, want your input on the path forward here. Senator Westrom actually had a thought that one route possibly would be for us to send this bill on to Commerce, where I understand they were anticipating to hear all of these bills on Thursday. Obviously, we're not going to move the other two bills that we haven't considered yet. But if you wish, we could move this one on with a commitment that it would then be re-referred back here to address the issues that we've raised. Or if you prefer to keep them all as a package, because there are a lot of testifiers that are common to all of them, we could lay this one over and then send them all together, if it's the wish of the committee to move them on to Commerce to be heard not on Thursday, but sometime after next Monday, when we will be able to revisit these bills in this committee. So what would be your preferred approach?
Mr. Chair, may I look at Nicole briefly and see, during this hearing, has there been any indication of which the Commerce Committee might prefer, hearing them all at once at a later time or having this on Thursday? Because I think I would go by their timeline. Mine is just to move the bills and get them passed into law, whatever makes that easiest for the folks who make this place run, Mr. Chair.
Give us a moment.
Moment given.
While we're doing that,
Yes.
I'm going to make sort of our end of meeting announcements. Our next meeting is going to be Wednesday, March 11, 2026 at 12:30 p.m. here in room G15. And then we will also be meeting this Friday, March 13, at 8:30 a.m. in the Minnesota Senate Building, room 1200. And our agenda that day will focus on reducing gun violence. We have, I think, 12 or 13 bills on the agenda, bipartisan authorship throughout the agenda as well. So members, just be prepared for that. And that's all I've got at the moment. Do we have any updated information? Commerce Committee prefers to receive all of them together to work through at a later date rather than this Thursday. So Senator Maye Quade, if you're concurring then with that guidance, so you're nodding your head in the affirmative, we will lay over Senate File 1857 for further consideration as well. And there being no further business, thank you for all your work here today, members. We are adjourned.